Okay, so you hear the term involuntary manslaughter thrown around in the news all the time. But what does it actually mean? It turns out it's one of the most misunderstood charges in the entire legal system. So today we're going to break down exactly what this charge is, especially under California law.
We're starting right here because honestly, the word manslaughter itself can be really confusing. Your mind probably jumps to images of intentional violence, right? But as you're about to see, that's not what this specific charge is about at all. And this quote really hits the nail on the head. With involuntary manslaughter, the death is, and this is the key word, unintentional. The whole case isn't about proving someone had malice or wanted to hurt somebody. It's about proving something completely different. So to clear away all that confusion, the best place to go is straight to the source, the law itself. Let's take a look at the precise legal definition under California Penal Code 192B. This is where the details really, really matter. All right, let's unpack this. You see that word again, unintentional. There was zero intent to kill. The death happened because of one of two things. Either criminal negligence, which is basically a legal way of saying someone acted so recklessly they showed a complete disregard for human life, or it happened while they were committing a lesser crime, something that's not a felony, like a misdemeanor. This right here is the absolute dividing line. For a murder charge, prosecutors have to prove intent. It's everything. But for involuntary manslaughter, the case is built on the absence of that intent. The tragic result is the same, but legally, it's the defendant's state of mind that separates these two crimes completely. To make this a little more real, check out these examples. Someone mishandling a gun that accidentally goes off, a caregiver who neglects their duties, leading to a death, or someone performing a really dangerous activity without taking the right precautions, and the worst happens. In every one of these situations, the person probably never intended for anyone to die, but their actions, or in some cases their lack of action, were so negligent or unlawful that they directly caused it. Now, it is so important to understand this. Just because it was unintentional does not mean the consequences aren't severe. Far from it. A conviction can mean up to 4 years in state prison, not to mention massive fines and a record that follows you forever. The legal system takes this charge incredibly seriously. So, now that we have a good grip on the charge itself, what happens when someone is actually arrested for it? Let's walk through the very first steps in that legal journey. Okay, so right after an arrest, things move in a very structured way. First up is booking. That's the administrative process. They take your personal info, fingerprints, photo. It's how you're officially entered into the jail system. Then, the prosecutors get the case and review all the details to decide whether or not to formally file charges. And finally, a judge determines the bail amount. They'll look at the seriousness of the crime, the person's criminal history, and whether they're a flight risk to decide on a dollar amount for their release while they await trial. And that brings us to our next big topic, bail. Bail is an absolutely critical part of this pre-trial period. And just to be clear, it's not a punishment. Think of it more like a financial guarantee, a promise to the court that the defendant will show up for all their future court dates. And because involuntary manslaughter is such a serious crime, the bail amount can be, well, staggering. We're often talking tens of thousands of dollars, sometimes even more. For most families, coming up with that kind of money in cash is just impossible. So that reality leaves people with two main choices. Option one, somehow you pay the entire bail amount directly to the court. If the defendant makes every single court appearance, that money gets returned when the case is over. But given how high the amounts are, most people have to turn to option two, using a bail bond company. So how does a bail bond work? Well, typically the defendant or their family pays a fee to a bail bondsman, and that fee is usually 10% of the total bail. Now, this fee is non-refundable. You don't get it back. In exchange for that fee, the bondsman posts the full bail amount with the court, which secures the person's release. It's what makes getting out of jail financially possible for so many people. And that release from jail is absolutely crucial. So for our final section, let's talk about why being out on bail can make such a huge difference in someone's ability to actually prepare their case. Being out on bail means you can be an active player in your own defense. You can meet with your lawyer freely, you can help gather evidence, you can prepare for trial without the enormous stress and the logistical nightmare of being locked up. That freedom before trial is directly tied to the ability to build the strongest defense you possibly can. And this all leaves us with one final, pretty heavy question. When the ability to effectively prepare for a trial is so closely linked to the ability to pay for your freedom, what does that really say about fairness in our justice system? It's a complicated issue for sure, and definitely one worth thinking about. Thanks for joining us.